Hi everyone, my name is Teacher Ilona. Welcome back to my channel. So you've been wondering, Basic Conditions of Employment Act. BCEA, what is that? Stay tuned, we're going to discuss it in full detail in this video. Enjoy. In today's video, we will be discussing, as I mentioned, the BCEA. It's the Basic Conditions of Employment Act in South Africa. If you have any questions, any parts that you're enjoying, anything that you'd like to add, I love to see the comments and I love the feedback. So please do post that down below. In these slides, I've made use of government textbooks and government resources, which I have added at the end of my video as well as my description below. I therefore do not take any credit in the information given in these slides, as well as these videos are not promoted or sponsored. The content in these videos is used for business studies students for grades 10, 11 and 12 so that it can assist them and help them in their studies. I've made use of the exact information to make sure that the information that you are receiving is accurate, is up to date, and is correct. And hence why I've made sure that the information hasn't changed and therefore I haven't reworded it. But I hope you enjoy this video. Please don't forget to give this video a like and to subscribe to my channel if you are a business studies student that needs a little extra help. Basic Conditions of Employment Act, or referred to as the BCEA. Let's get started. So looking at the purpose. What is the purpose of this act? Why was this act brought into place? So it provides clear terms and conditions of employment for employers and employees. It sets the minimum requirements or standards for the employment contract. It regulates the right to fair labor practices as set out in the Constitution. It adheres to the rules and regulations set out by the International Labour Organization. And it regulates the variations of business conditions of employment. And there's also an advance in economic development and social justice. So, all in all, this is an act that will state working hours, working conditions for the employee. So should the employee, that's what it mentioned by the requirements or the standards. If they want to know what is the standard, what is expected of them, that's what this act is in place for. This act is also in place to assist employees of knowing what is the standard, and therefore they can look at what their company is providing them and they can see if they are being unfairly treated or mistreated in that way. Then the impact of the BCEA. There are positives/advantages as well as negatives. Let's look at the positives. It creates a framework of acceptable employment practices. So, for example, working hours and leave that can be taken. It promotes fair treatment of employees in business. It encourages consultation between employers and employees. It outlines minimum requirements that form the basis of employment contracts, like I mentioned. Work hours are specified so that the employer cannot exploit the employees. And the rules and regulations are very specific, which clearly guides the employer on how to deal with employment issues. And the employees are permitted to consult the labor unions in cases where the BCEA conditions are being violated. There we also need to look at this in relation to the LRA, the Labor Relations Act. Employees may submit complaints to labor inspectors who can then address it. So, as we mentioned, these are some of the positives. These are the good things for both the employer and the employee. It basically sets the standard. It sets the requirements of what the basic conditions. So we're not talking about the most amazing conditions of working. These are the basics. These need to be met. at least, and then we can look from there on. And then should there be an issue, the employee can submit a complaint to the labor inspectors, and then they will inspect the situation. And should there be an issue, they can then take it further and discuss it with the employer. Then the disadvantages, the negatives. Developing or drafting a formal or legal employment contract can be time-consuming and costly. Businesses may regard employment contracts as negative and may not want to implement them, which will result in non-compliance and penalties thereof. No employer may force an employee to work more than 45 hours in a week. This may result in reduced productivity and 1.5 times the normal rate of pay for overtime worked on weekends and Saturdays. And then there's the double rate of pay for overtime worked on Sundays as well as public holidays. So sometimes the employers see this as a negative in the way that some employers feel that you should work extra hours and extra time. That extra time needs to be given as 1.5 times their normal pay rate. So if they're being paid 50 Rand, you need to pay them 1.5 times that. If you're making them work overtime on the weekends, on the weekdays, as well as Saturdays. And then they might say, oh, you know what, who can come in on Sunday to come and assist us and help us? Again, there's the exact same thing, is that they need to pay them double the working rate. So I think in this way, employers don't like it because they want the employees to work overtime, but the employees also have that right. So that's what they mean by the disadvantages there. And then creating this contract can be quite extensive. If you go and Google a type of contract, a normal standard contract, you'll see there's loads of information. Each contract should be roughly, I would say, between 14 to 16 pages. So there's quite a lot of pages, and they might find it time consuming and maybe just a waste of time. They are doing themselves in. That's not a good idea, but that's what is meant by that. And then more negatives. Overtime must be paid either at the specific rate for overtime, or an employee may agree to receive paid time off. The Minister of Labour may prescribe a maximum permitted working hours, which includes overtime for health and safety reasons for a certain category of work. So example there would be like mine workers, or if you're working in a factory, so there might be fumes and stuff involved that you can't work X amount of hours because it's actually not safe and it's going against health and safety regulations. And then there could be a bargain off where an employer says, all right, if you work this Saturday, I'll give you Tuesday off. Or if you work on the Saturday, I'll give you Monday off. They can do that as a bargaining agreement, but it has to be an agreement on both sides. And then we're looking at leave. What are the types of leave that we get? So workers are entitled to 21 consecutive annual leave days per year, which amounts to, there is 1 day for every 17 days work, or 1 hour for every 17 hours worked. An employer can only pay a worker in lieu of leave if that worker leaves the job. So with this, workers are entitled to 21 days annual leave, which is 1 day for every 17 days work. Also, an employer can only pay a worker their leave, so they pay out their leave. So if you're leaving your job, if they do a payout, then they can pay out your leave. But normally they don't pay you back for leave. You can't make an agreement to say, I've got 10 days leave, can I have that as cash? They will advise you to take it as leave days, not take it as cash if you're still staying at the company. Then we have sick leave. So workers are entitled to 6 weeks of paid leave in a period of 36 months, and that is 3 years. So it's basically 1 day paid sick leave for every 26 days worked during your first 6 months of employment. A medical certificate may be required before paying an employee who is absent for more than 2 consecutive days who is frequently absent. So if you are absent for more than 2 days in a row consecutively after each other, then they may need a medical certificate. And then, as mentioned, 6 weeks paid leave for 36 months, but this needs to be accumulated, obviously. So it's 1 day paid sick leave for 26 days worked. Maternity leave. A pregnant employee is entitled to 4 consecutive months leave. A pregnant employee may not be allowed to perform work that is hazardous to her unborn child. And the starting date is usually any time from 4 weeks before the expected date of birth or on advice of the doctor or the midwife. So a pregnant employee is entitled to 4 consecutive months maternity leave. And then the hazardous that they're referring to is perhaps chemicals or work where she may be injured. So going up onto scaffolding or something in that regard. So that'll just need to be looked at more carefully. And then the starting date for the leave can start any time from 4 weeks before the date of birth, the expected date. Family responsibility leave, 3 to 5 days paid leave per year on request in the event of the death of the employee's spouse, life partner, parent, adoptive parent, grandparent, child, adoptive child, grandchild, or sibling. An employer may require reasonable proof before granting this leave. Male employees are entitled to a maximum of 3 or 5 days paternity leave when his child is born. So 3 to 5 days per year on request in the event of death of the following. Then an employer may need proof, so perhaps a death certificate or perhaps a date of the funeral, even the program of the funeral could be suffice. But I would say the best case scenario would be the death certificate, knowing that that obviously can't be issued immediately and that we'd need to wait for that from Home Affairs. Male employees are entitled to a maximum of 3 to 5 days paternity leave. This might have changed to 10, but I'm going to stick with the facts that we have in front of us, which is 3 to 5 working days paternity leave when his child is born. So if women get maternity leave of 4 months and males, men, the dads, get 3 to 5 days. Meal breaks and rest periods. Workers must have a meal break of 60 minutes after continuous work, hours of work, sorry. This can be reduced 30 minutes by written agreement when working less than 6 hours per day. A worker must have a daily rest period of 12 consecutive hours or a weekly rest of 36 consecutive hours, which must include Sundays. So should a worker work for 5 hours consecutively, then they need a 60-minute meal break. Okay, so if we work it out, if a company starts at 8 o'clock, that's 9 o'clock, 10 o'clock, 11, 12, 1. So after 1 o'clock, they should go on for lunch. It can be agreed that it can be taken at 12 o'clock or 2 o'clock, but that needs to be by written agreement. And it has to be 60 minutes. If it is shorter than that time and the employee is working for 8 hours, then it is seen as illegal. And as I mentioned, a written complaint could be written in that regard. Then, as said, this can be reduced to 30 minutes by written agreement if the employee is working less than 6 hours. So they only work until 1 o'clock, then 30 minutes can be agreed upon. Then a worker must have a daily rest period of 12 consecutive days or a week rest period of 36 consecutive hours, which includes Sundays. Okay, that's normally where workers will get the Saturday, Sunday off. That's normally where that's coming in play. But as I mentioned, I have worked for a company in the past where the working conditions, it was 10 hours of working per day, and then we were only allowed 30 minutes of mealtime, which was unacceptable and is completely illegal, because to work 10 hours a day, that's the first thing. And then secondly, to only receive 30 minutes of work. I no longer work at that company, but yes, that's an example of exploitation of the workers. Public holidays. Workers must be paid for any public holidays that fall on a working day. Work on public holidays is by agreement and paid at double the rate. So, should they work on a public holiday, they need to be paid double the rate. And then workers have to be paid for the public holiday should it fall on a weekday. So if a public holiday is on the Tuesday, the employee gets the day off and has to be paid as such for that day. If they are working on that public holiday, it's double the rate. Termination of employment. The contract of employment may only be terminated following 1 week's notice if the worker has been employed for 6 months or less. A minimum of 4 weeks' notice must be given if the worker has been employed for a year or longer. An employee must give notice in writing. The employee who is retrenched, dismissed for reconstructing reasons is entitled to 1 week's severance pay for every year of service. To terminate the contract, basically to leave the company. If you have worked for less than 6 months, 1 week's notice, which is a Monday to a Friday, or from the Tuesday that you may have resigned to the next Monday or Tuesday. A minimum of 4 weeks must be given if the employee has worked for a year or longer. And then employees must give notice in writing. So that could either be a letter that is written out. Normally, it's via a letter sent by email or just an email written out. No reason needs to be given in this regard. It would be best to give a reason, but just to state that you are giving formal notification of your resignation and your last date will be stipulated as such. And then normally just a thank you to say, thank you for the company for providing me this opportunity, something as simple as that. And then if the employee has been retrenched or dismissed for reconstructing reasons, then they need to receive a week's severance pay every year of service that they work there. Child and forced labor. As we know, this is illegal. It is illegal to employ a child younger than 15 years of age. It is also illegal to force someone to work. Businesses may employ children over the age of 15 if employment is not harmful to their health, well-being, education, moral, and social development. Minors under the age of 18 years may not do dangerous work meant for an adult. Okay, so illegal to get a child to work under the age of 15. Whether it's consensual or not, should the child of 13 years old want to work, unfortunately, you are not of legal age to work. They are not allowed to. It's illegal to force someone to work. Someone doesn't have to work. If they don't want to work, they don't have to. Okay, so it's illegal to get someone to work. And then if the work that they're doing, okay, is dangerous and could affect, as we mentioned, the following, then, and the child is over the age of 15, then we say it's that gap between 18 and 15. If the work is perhaps too dangerous for them and it's meant for an adult to do, then also they shouldn't be doing that work. We've reached the end of the video. Here are the resources that I've made use of. I have put them in my description below. You'll see that there are two links. There is this link and there is this link. If you go onto that link, you will actually get a PDF copy of the study guides that I'm making use of for these notes. They are very nice study guides. I've made use of both of them because they are both different in their own way. And they're very, very helpful to study from. Most of the study guides do also come with extra resources and exam prep and questions. So it's very, very good to use and it's very helpful. Thank you so much for watching my video and thank you for supporting my channel. I really appreciate all the feedback I've been given. It really means a lot to me, guys, and it means a lot to me as a teacher. So thank you so much. Keep that up and all the best with your studies. I know the March tests are coming up. I wish you all the very best and I'm glad to see how my videos have been helping and how they have been guiding you guys, and I will continue to do so because that is the purpose of this channel. But please don't forget to like my video and subscribe to my channel. Thank you so much for your support. I'll see you in my next video. Bye for now.